Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a news story that's been sent to me by several people. It's got an interesting firearm related question. Let's have a look. This story, and I'm not going to go through all of it, just the key bits here. Cougar harassed with slingshot in Banff National Park, prompting rare charges. A Saskatchewan man faces rare charges under National Parks wildlife regulations and potential fines of up to $125,000, not small potatoes, after allegedly using a slingshot to hurl projectiles at a cougar in Banff National Park. I should note, I doubt he's going to see anywhere near the maximum fines. The maximum fines would be for the worst possible scenario. According to Parks Canada, an eyewitness provided key evidence, a number of photos that wardens used to build a case. Skipping over a little bit, they also had a vehicle description. A 40-year-old man from Prince Albert, Saskatchewan has been charged with 2 offenses under National Parks wildlife regulations: disturbing an animal in a national park and possession of a loaded firearm outside of a vehicle in a national park, charges that are rarely laid. Parks Canada said that under the regulations, a slingshot is considered a firearm. So that's the bit that people were asking about. Is, wait a minute, how is a slingshot considered a firearm? That doesn't make much sense. That doesn't seem anything like a gun. And they're right. If you think about it in terms of the criminal code, a slingshot would not meet the criminal code definition of a firearm. But this illustrates a very interesting point, which is that different legislation can have different definitions for the same thing. So what is a firearm in the criminal code? The definition might be different under the National Parks wildlife regulations. Let's have a look at that here. So National Parks wildlife regulations, we see interpretation. That's going to be the section that contains the definitions we're looking for. And firearm. Firearm means any weapon from which any shot, bullet, or other missile can be discharged and that is capable of causing injury or death to wildlife, and includes anything that can be adapted for use as a firearm, and anything that is designed for or capable of being used for the purpose of causing injury or death to wildlife. As a lawyer, when I see a definition like that, the first thing I want to do is check to see if other terms that they refer to here are defined. In particular, terms that a lot will weigh on. So weapon is one of those. Shot, bullet, or other missile might be less so. And wildlife. Any of those things I want to see if there's a definition for here. Now, I don't see anything for shot, bullet, or other missile. Similarly, nothing for weapon, but we do have a definition for wildlife. Wildlife means all wild mammals, amphibians, reptiles, birds, fish, insects, and other invertebrates, and any part thereof, and includes their eggs and young. So when they say wildlife, that means anything from a bear, a wild mammal, to a wild insect. Wow. When we go back to our definition here, anything that is capable of being used for the purpose of causing injury or death to wildlife, when we think of an insect, and especially including the eggs or young of an insect. So not just anything that could hurt a fly, but anything that could hurt a baby fly in its most vulnerable state. The only limiting factor that we see here is weapon. And so a lot is going to turn on the definition of weapon here. I'll tell you that the first thing I did was open up the case law and see if I could find some case law that defined weapon in this context. Unfortunately, I couldn't. And part of the reason is that wildlife cases tend not to get reported as much. So I don't have a definition for what weapon means here. Normally I'd be inclined to say, well, let's use the criminal code definition. The problem is that the criminal code definition is really focused on persons, not animals. So I've brought up the definition of weapon, and this is from the criminal code. They note weapons means anything used, designed to be used, or intended for use in causing death or injury to any person, or for the purpose of threatening or intimidating any person. There's also a section that notes that this includes things for tying people up for certain criminal offenses. This isn't going to be a whole lot of help when we're looking at animals, because first, causing injury or death to any animal may be, but the whole design to be, it's not clear whether this is really on point. So I brought up the definition of weapon here. And they note weapon, this is from the criminal code. So I've brought up the definition of weapon from the criminal code here. It notes weapon means anything used, designed to be used, or intended for use, A, in causing death or injury to any person, or B, for the purpose of threatening or intimidating any person. We can see how that's not going to be terribly satisfying here when we're talking about a statute that really is addressed towards animals. It's just not what they were thinking. It's clearly outside of what they were thinking, and it's very hard to really wrap our head around a parallel, at least for Section B, for the purpose of threatening or intimidating any animal, if we just wanted to swap in person for animal. I don't know that that makes a whole lot of sense here. So I think we've got a bit of a problem in that we've got a term that appears to be just completely undefined. Let's go back to our firearm definition here. So where we see firearm means any weapon that can do any of this stuff, well, there's two ways of reading this, because we see that it includes anything that can be adapted for use as a firearm and anything that is designed for or capable of being used for the purpose of causing injury or death to wildlife. We could say that as includes even if it's not a weapon. So that meaning would essentially make weapon a useless term that we can just ignore. Or weapon might be a limiter on everything here, in which case it would only include those things if they are weapons. But in that case, we don't know how broadly to interpret weapon. Weapon could be interpreted the same way the similar provision in the criminal code is, which is essentially just to ignore that sentence. Or weapon could be interpreted very restrictively. We could view it as including things like firearms and rifles and probably crossbows and hunting bows. But we might be in a position where we're saying weapon is there in order to exclude things that maybe fire a projectile that could hurt a fly, but that we aren't really that concerned about. However, if we take this as broadly as it can be, if we take this as weapon is not a limiting term here, then we start including some really ridiculous things. As an example, we would include one of the chuck it things. They're a stick with a little cup on it that you use to throw a tennis ball for a dog. That fires a shot, bullet, or missile, the tennis ball, which can cause injury or death to wildlife. If that hit a baby fly, it would certainly squish it. You can think of the bug assault gun, which is sold. It's a little sort of toyish device that shoots salt that you use to shoot down flies. It would also include things like, for example, a Nerf gun. Because if you fired a Nerf gun at close range and you hit a fly, you'd probably squish it. A mosquito is wildlife. The more you know. A dart gun, like a toy dart gun that shoots those little cheap plastic things you'd see at the dollar store. Does that also qualify? All of these are somewhat unanswered questions, and these are the kinds of things I might put to a judge in suggesting that maybe the definition should be narrower here. Because it's really hard to imagine when they have laws saying that you can't have firearms in national parks, that what they really contemplated was that you couldn't have a Nerf gun. Or that you couldn't have a thing to throw a ball for a dog. Or any of this stuff. That it's really hard to fathom that that's what they had in mind here. However, let's go and actually look at what they're saying he was charged with. And this is going to be, I'm going to have some comments on what they described here. So remember, I'll just go back here. Give me 1 second. Sorry, I'm just trying to pull up the right. There we go. So we see here they said that he's charged with possession of a loaded firearm outside of a vehicle in a national park. Loaded firearm outside of a vehicle, national park. Going back here and looking at the actual statute, we see no person shall be in possession of a firearm in a park unless the firearm is not loaded and is transported in a case or is wrapped and tied securely in such a manner that no part of the firearm is exposed. We already know that a slingshot is maybe a firearm because maybe, depending on how strictly we apply weapon, it might or might not fall in there. But I don't see vehicle mentioned in this section, so I don't know if this is the section that he's supposedly charged with. I also don't see... So we'll move on. No person shall have a loaded firearm in or on a vehicle, vessel, or aircraft. But they said he was charged with having one outside of a vehicle. So this doesn't seem to be the section he's charged under. So now we have no person shall carry a firearm or trap outside a vehicle, vessel, or aircraft unless that person either has a permit, which it doesn't appear that he's likely to have a permit, or the firearm or trap is being carried directly to or from a vehicle to that person's premises, or the reverse. So either from your house to your car or from your car to your house. But this one doesn't mention loaded. This is probably the section that they mean, but the media here has apparently invented a charge or mixed multiple charges together. I'm not a huge fan of this. The way to fix that would be for me to order the information and endorsements, but that would mean that this video would have to come out a week or two later, and many of you you're curious now. So I don't want to wait a week or two. I want to get you some answers while this is still timely. But I don't know which section this is under. I wish the media would do better on reporting on criminal justice and especially firearms related stuff in the criminal justice sphere, but that's not going to happen today. Going back, the loaded part raises another interesting question because we have a definition for loaded. Loaded with respect to a firearm, and keep in mind that's the definition we were just looking at, that very either broad or else maybe less broad definition, we don't know. With respect to a firearm means that a live shell or cartridge is present in the breech, chamber, or attached magazine of the firearm, or that a projectile is present in the barrel of the firearm. Well, that causes a bit of a problem for us here. If the section that he's charged under requires the firearm to be loaded, we're in a bit of a problem. Because the first issue is if live shell or cartridge. Slingshots don't usually shoot live shells or cartridges. I mean, you could. There's nothing that would stop you from getting a slingshot and getting a cartridge, which is, if you're not a gun person, people usually incorrectly say bullet to refer to a cartridge. The difference is that the bullet is the projectile. It's the little lead piece at the end that goes flying and hits whatever target, whereas cartridge refers to the entire apparatus. The brass, the primer, the powder, the projectile. So you could fire something like that out of a slingshot, but that would be weird. I don't see a whole lot of people shooting live ammunition out of slingshots. So that's our first problem. Second problem is breech, chamber, or attached magazine. I haven't known slingshots to have any of those things. So a slingshot doesn't seem like it could qualify under that section. But there's an or, so we've got another route here. Or that a projectile is present in the barrel of the firearm. Projectile is good, because a rock that you're shooting out of a slingshot, that could be a projectile. However, in the barrel of the firearm, slingshots don't typically have barrels. I can't say never, but I'm not familiar with slingshots with barrels. Unless he's got a slingshot with a barrel in it, it seems like it's impossible for the slingshot to have been loaded under this definition. And this is the definition that matters. It looks like you just cannot load a slingshot, nor can you load a bow or load a crossbow under this definition. That's interesting. So ultimately, we don't know what we're looking at here, but there is going to be I would suggest a live issue as to whether or not this slingshot is a weapon as defined in this, and if it's not a weapon, does that matter in terms of it being a firearm? Because if this slingshot is found not to be a firearm, then he's looking at acquittal on that charge of having a firearm in a park. The other thing is, if the slingshot has to be loaded for the section they've charged him with, he's going to walk on that, because I can't see how that slingshot could be loaded unless a judge is going to essentially rewrite this section and read in a whole lot of additional stuff, because somehow you'd have to find that the pouch of a slingshot is either the breech or the chamber or the attached magazine of the slingshot. That's a big stretch. Or the barrel of that's too much of a stretch in my view. This also suggests, in terms of the drafting, that they really were thinking of guns here. But their definition, they're claiming, extends way beyond guns to slingshots. It's unclear what ultimately is going to happen, but it's really interesting that these charges have happened. I hope this ends up being a reported decision, and so that we can follow it up later. Unfortunately, most decisions in Canada end up not being reported, so it's unlikely that unless I make a drive and watch court processes, and even there it's not clear that it's going to be sort of in open court, or order the transcript later, it's unlikely we're going to find out what happens here. But it certainly raises some interesting questions. At any rate, thank you for watching. I hope this has been interesting or educational. If it has, please like, share, and subscribe this content. I also want to give a thank you shout out to my $10 Patreon supporters. Your support is appreciated, and it's going to help with things like ordering transcripts and possibly doing some experiments. There's some questions I've had for a fairly long time. I'm looking forward to exploring some of those, and some of them require some physical experimentation. I hope this has armed you with some knowledge, and thank you for watching.